All right. Good morning or afternoon. My name is Nina Vorndren, and I'm the Business Development Manager at Contact Center Compliance. Thank you for joining today's webinar, Advanced TCPA and DNC Compliance, Reducing Risk in 2017. The webinar will be presented today by Eric Allen and Ryan Thurman. Before we get started, just a few housekeeping items. All lines are muted, so please utilize the question and chat pod to ask your questions during the webinar. Due to the amount of content that we do have to review today, if we do not answer your questions during or at the end of our webinar, we will ensure follow-up via our Q&A document that will be sent out to all attendees. You will also receive a link to the copy of today's deck. So you've probably heard of our featured speaker today, Eric Allen. He is a partner at the Salt Lake City-based law firm of Allen, Mitchell & Allen. Eric's practice focuses on TCPA and TSR compliance and defense, and he represents hundreds of telemarketers, sellers, debt collectors, lead generators, and software dialer vendors around the globe. Eric has also been admitted in federal courts around the country to defend consumer class action cases. Ryan Thurman is our Sales and Marketing Director at Contact Center Compliance. With over 15 years of experience, he is recognized as a compliance industry expert with focus on state and federal telemarketing and privacy regulations, including TCPA, FTC, state and global compliance regulations. He also served as the regulatory chair of the West Coast chapter of PACE and moderator of the Contact Center Compliance Officers Forum. We have included a disclaimer as well as a quick agenda for your review. So without further ado, I will go ahead and introduce Eric, and we'll get started.
Well, thank you very much. It is always an honor to be with and speak for Contact Center Compliance. I will move quickly, but we will absolutely save time, at least 10, maybe 15 or so minutes for questions. Today is meant to be a higher level review of important compliance principles, a deeper dive into the details and some of the brand new stuff out this year. We'll talk about TCPA and DNC, what's new this year, the overdue decision in the ACA International's appeal against the FCC. We'll talk about new leadership on the FCC and FTC and what that means. We'll talk about B2B versus for-profit, nonprofit, some dialer cases, cutting-edge consent hacks, and risk mitigation techniques. But before we get into the details, let us go back to the basics for just one moment here. If you fall asleep after this slide, this will probably still be the most important analysis for today. If you and your organization can avoid making these 5 or so mistakes, then most of your liability is out the window. The vast majority, 90+% of all TCPA and similar lawsuits, whether individual or class actions, are filed and allege one of these 5 common mistakes. First, you may not use any form of an auto dialer to call or text any cell phone for marketing without express written consent. Again, you cannot use any form of automatic telephone dialing system to call or text any type of cell phone for marketing without written consent. Well, what about non-marketing? You still need consent. You cannot use an auto dialer to send non-marketing messages or text to any cell phone without at least express consent. Not written, but express consent. It's a lower standard of consent, but it's consent nonetheless. It can be implied in certain situations. We'll talk about that. Third, marketers may not deliver pre-recorded messages to any consumer line, cell or landline, without written consent. So you cannot deliver robocall, recorded marketing messages or pre-recorded voice messages to any line, wireless or wireline, without written consent. Fourth, you can't continue to auto dial after someone has revoked consent. So even if you have well-documented written consent for your automated marketing message, or at least implied express consent for your automated non-marketing message, Once someone revokes that permission or otherwise opts out, you have to stop calling immediately. Finally, you may not telemarket to numbers on the national do not call list without either written consent or an established business relationship. So don't do these things. If you forget everything else from today, make sure you and yours don't do these things, and the chances of you getting hit with a suit drop to next to nothing. Let's talk about the details, the finer points, and what is brand new in 2017. First, this year, the FTC's new avatar or quote-unquote soundboard technology policy has taken effect. This is very, very new. We'll talk about that, what the new rule is, why it matters, why the FTC's position changed, etc. Also this year, the court invalidated a part of the FCC's fax disclosure rules. We don't talk about the faxing rules much, but they're still important, and there are still a handful of TCPA fax cases, including class actions, filed every year. There are still faxing rules, there are still fax disclosure rules, but they did overrule the FCC on one important point regarding fax disclosures on solicited faxes with permission. Also, the FCC has received this year and is now soliciting comments on a petition regarding ringless voicemail. This is something new. We'll talk about what ringless voicemail insertion is, why it matters, what the petition is asking for, and some best practices. Fourth, we'll discuss how the FCC is considering an important petition to end that implied consent for non-marketing automated messages. We'll talk about that petition, what it means, kind of a spooky thought. A lot of us rely on that implied consent to make debt collection calls, for example, customer service calls, delivery confirmation, surveys, and the like. We will discuss the FCC and how they're still considering a petition filed last year, but haven't ruled yet on business telephone numbers that are on the consumer do not call list. I've seen statistics saying that at least 10% of the telephone numbers on the national consumer do not call list are actually business lines or dual purpose lines at the very least. We'll talk about what that petition means. Also this year, the FTC fine goes up again, slightly. Everyone saw just within the last week the very unfortunate $280 million civil penalty awarded by a federal judge in Illinois against Dish Network. That came shortly after, I believe it was a $60 million suit in the private TCPA class action. We'll talk about what we can learn from that. There have been, of course, a handful of preview or click-to-call dialer cases in late 2016 and 2017, thankfully mostly in favor of our industry. We'll quickly review those. We'll talk about the American Collection Association's lawsuit against the FCC and how that's ripe for a decision on the auto dialer issue, reassigned numbers, and the right to revoke. And finally, we'll get into briefly the new administration, new Chairman Pai, Pai and O'Reilly both speaking out this year of possible coming TCPA reform. So, soundboard technology. What is soundboard technology, or avatar calling? This occurs when a live telephone agent, let's say they're sitting in the Philippines, just for this example, initiates a call. They're listening to the call, but rather than speaking their own natural voice, and they may have a thick accent, for example, instead of speaking with their organic voice, instead they press buttons to play short, pre-recorded words and sentences. These are snippets that were recorded ahead of time by American voice talents. Well, is that a live call or is that a robocall? There's a debate there. Well, back in 2009, Lois Groisman at the FTC, she's the Associate Director of their Division of Marketing Practices, published a letter, not a rule or regulation. This is not a law, but in some respects it has the same effect. This was a staff opinion letter concluding that because Avatar always used a live agent who was always listening, they just weren't concerned about it, and they would not treat it like a robocall. And that was the policy of the FTC for years. The FCC has still never spoken on avatar technology. However, in early 2016, Ms. Groisman solicited feedback from industry members because the agency rather, had begun receiving avatar-related complaints allegedly, and she herself reported receiving a kind of a bad example of an avatar call that was mishandled. It created a bad interaction, and she wanted to investigate further. Well, unfortunately, she rejected the industry's efforts to try and get them to either leave the exemption in place or if they were going to lump avatar back in with traditional robocall to create some sort of a single or maybe dual line restriction so that it would still be allowed at least for entities where the agent was listening to only one call, for example, at a time, or perhaps exempt entities that participated in and were certified through some self-regulatory organization. They were unconvinced. On November the 10th, so late last year, the FTC published a brand new staff advisory opinion letter revoking the old 2009 avatar letter and indicating that 6 months from that time they were going to treat avatar the same as all other robocalls. The Soundboard Association sued but lost. They did get the effective date stayed 1 week, not a big deal, but that new avatar policy officially took effect just a month ago on May 19, 2017. What are the implications? Avatar is certainly still legal, just like some robocalls are legal, but you need to obey certain rules. So for example, you can still, just like you can make traditional pre-recorded calls or use an artificial voice, you can always still use avatar when you're calling with consent. In general, when you're calling a landline for non-marketing purposes, but watch out, some of the states are more strict. If the caller is a bona fide nonprofit charitable organization, private contractors are not exempt, though, necessarily. And finally, most political calls are exempt unless you cross the line and start selling something. Also, you've got to follow other normal behavioral FTC rules like the National Do Not Call List, disclosures, curfew, record keeping, etc. I predict that if we don't see the first big avatar lawsuit by the FTC this year, it will certainly be in 2018. I think we'll see at least a few civil investigative demands go out this year. If your organization uses avatar, that's okay. Just make sure you're still exempt. Make sure you're following the rules, and don't be one of those abusers of the technology that led to this policy change in the first place. If your agents are handling, 8, 10 calls at a time, trying to push buttons and play recordings for each one, then you're probably creating some bad interactions. You might be generating complaints. You might be at the top of the FTC's enforcement list on their coming avatar enforcement. Okay, what about faxing? Quickly, not a lot of us still have fax machines or send or receive faxes, but it does still happen. The FCC this year, or I'm sorry, the DC Circuit Court rather this year has overruled the FCC's fax disclosure rule, at least with regard to faxes sent with permission, with either consent or with someone or to someone that the sender has an existing business relationship with. The FCC previously held that even on those solicited faxes that were sent with permission, you still needed the fancy little opt-out language on that first page, which were easy to mess up and were the cause of a decent number of class actions over the years, even now. Well, on March 31 this year, the DC Circuit Court of Appeals held that the FCC did not have authority to impose those behavioral rules on solicited faxes. This is what the court said, quote, "The fact that the agency, the FCC, believes that solicited fax rule is good policy does not change the statute's text. The text of the act does not grant the FCC authority to require opt-out notices on solicited faxes." So look, FCC, you didn't have authority from Congress to do that. You were only supposed to make rules and opt-out stuff for unsolicited faxes, cold faxes. You went beyond your authority. This is what Chairman Pai said. This is right out of the mouth of the new head of the FCC. This is what he said on that same day this year. "Today's decision by the DC Circuit highlights the importance of the FCC adhering to the rule of law. I dissented from the FCC decision that the court has now overturned because, as I stated at the time, the agency's approach to interpreting the law reflected convoluted gymnastics. The court has now agreed that the FCC acted unlawfully. Going forward, the Commission will strive," and this is a prediction for 2017 and the years to come. "Going forward, the Commission will strive," he says, "to follow the law and exercise only the authority that has been granted to us by Congress." And of course, we saw just last week the court denied that motion for a rehearing en banc on that appeal. So when faxing, if you have EBR or consent, and if that's well documented, you don't need that fancy opt-out disclosure. You still need it when sending cold faxes. That decision is a great sign. What about ringless voicemail insertion, a cutting-edge technology that has been around for a while but really just become popular, I think, in the last couple of years. I just wanted to mention this briefly because, admittedly, there has been virtually no litigation to date against users of the technology. A couple of isolated cases that I'm aware of, but not much. But I still wanted to point out that this year the FCC has received a petition from a vendor of the technology to bless at least their version of the technology. What's the argument? Well, ringless voicemail, and there are a number of different variants and delivery methods out there, but the argument goes like this. When we deliver a voicemail to a person's voicemail box without calling the phone or making the phone ring, and if we deliver it in such a way that it doesn't even show up on the phone bill and cause them to incur a charge, those deliveries or those insertions are not quote-unquote telephone calls. And therefore, the argument goes, and I think this is a pretty strong argument, if they're not telephone calls, then none of the telemarketing rules in the TCPA or TSR that apply to telephone calls apply to this technology. So, for example, the TCPA rule that says you can't use an auto dialer to make a telephone call to a cell phone without written consent arguably would not apply. The TCPA doesn't have a definition of a telephone call, so all we have right now is a very strong argument. But now we have this petition. There is a petition before the FCC saying, dear FCC, please bless this technology. Tell us that it is not a telephone call and it doesn't violate your rules. The FCC solicited comments. If you didn't comment, it's too late. Those were due, I'm sorry, the reply comments I think were due June 2, last week. I think responsible use is the key. It could be months or years before the FTC rules on this petition, if at all. So responsible use is the key. Let's not abuse the technology like some users of Avatar. Let's not abuse the technologies like some of the early text blasters who caused the FTC to define a text as a telephone call. Responsible use is key. Certain rules will apply regardless. For example, the National Do Not Call list. Regardless of the determination on ringless voicemail, the DNC list will always still apply. Why? Because that rule, at least in the FCC's TSR, doesn't use the term telephone call. It says you can't deliver a telemarketing solicitation to someone on the DNC list. So it doesn't matter if it's a call or not. You can't telemarket to people on the DNC. What other rules apply? You have to honor curfew. Those are those time of day restrictions. Disclosures. You have to honor opt-outs. And not that this is required, but I would encourage you not to make sure your ringless voicemail insertions don't sound like pre-recorded announcements. If your insertions sound like attention homeowner blah blah blah, you're going to be sued by someone who mistakes your ringless voicemail drop as a pre-recorded robocall. So let's use the technology responsibly and not for spamming. Use it when you have consent. Use it for non-marketing. Use it with people you have relationships with. Continue to scrub. Continue to engage in some of the other best practices we'll talk about today. And avoid higher-risk states. We all know very well, Indiana is an example. There are some states out there that have made a reputation for being really aggressive on telemarketers, especially telemarketers that use recording. So just be very careful and maybe do a statewide analysis as well and decide where you as an organization believe that this technology is safe. Okay. There's also a petition this year to end that implied consent for automated non-marketing calls. What a spooky thought. Debt collectors, survey companies, brands that are doing, sending delivery confirmations or making automated customer service calls, etc., all to some extent have relied on this implied express consent. Recall that for marketing automated messages, you need written consent, but for non-marketing calls, you get all you need is this express consent. I know it seems like an oxymoron, implied express consent, but that's what the FCC said years ago. They said, you know what? When someone, like a debtor, gives their telephone number voluntarily to the company, like a creditor, for example, that's implied consent for them to receive automated calls at that number for normal business purposes. There were some caveats, and there still are. When you collected the number, there can't have been any conditions on its use, and it's only effective until they opt out of their numbers reassigned. And the messages you're sending now have to be closely related to the purpose for which the number was originally collected. But it's a great exemption. There's this petition now by the two Craigs, we'll call them, Craig Cunningham and Craig Moskowitz, very frequent, well-known TCPA serial litigators. They petitioned the FCC saying, you know what, FCC, back in 2013 you created this written consent standard for marketing messages. We think that non-marketing messages are just as invasive, and so you should hold them to the same standard. I would be extremely surprised if under the leadership of Commissioner Pai, the FCC did not deny this petition. I would be very surprised, but still a scary thought, so let's watch it. Again, they've solicited comments, but they have not ruled. This would be a great one, I think, for the FCC to come out and rule on. Okay, what next? Business numbers. What is a business number anyway? Is a business line because it's used for a business purpose? Maybe. Is a business line because the owner, the subscriber on the line is a corporation, an Inc.? Is it if Eric Allen Inc. owns the line instead of Eric Allen the individual? Is that what controls? We don't know for sure. There's been some litigation over this in the B2B space. And Todd Bank, sorry Todd, spelled your name wrong. Should be 2 Ds there. Maybe stop suing us and we'll learn to spell your name right. Anyway, the bank petition, which has been received by the FCC, asks the FCC to protect business numbers that are on the consumer do not call list. Why is that spooky? Well, again, maybe 10%, maybe more of the numbers on the DNC list are arguably business numbers. I tell all my B2B marketers, scrub consumer DNC anyway. There's these dual purpose lines. There's a debate about what a business number is. You don't want to accidentally call a consumer number that you think is a business number. B2B should just scrub consumer DNC. But if you're not, watch out for this petition. They want the FCC to protect business lines that are already on the consumer DNC, which wasn't created for the purpose of protecting business numbers. Okay, next. More about B2B versus B2B, or B2C rather. A lot of it's called businesses instead of consumers, or at least we try to. Well, the cell phone rule is ever present, even for B2B marketers. You cannot auto-dial a business cell phone without consent, just like you can't auto-dial a consumer cell phone without consent. Cell phones are super, super sacred now. It doesn't matter if a business owns that line or uses that line. It's protected by that written consent rule, or for non-marketing messages, the implied consent rule. Under the TCPA and TSR, business landlines aren't protected from robocalls. Business landlines, but in many states, I would say probably at least half, they have a local robocall restriction that doesn't exempt B2B. For example, Washington State, there are a lot of B2B class actions filed in Washington State, and the basis for those lawsuits is a local Washington State code, a local robocall ban that has no B2B risk. So you know what, B2B, go ahead and scrub consumer DNC. Do your litigator scrubs. Do your cell scrubs. Don't just think, oh, I'm B2B, so I'm exempt from all this. We all remember last year the FTC increased their fine from $16,000 way up to $40,000 a violation. And you could have multiple violations a call. That stacks up quick. Well, January this year, they bumped it up again, just slightly, citing inflation. The current fine, the new fine, this year for any violation of TSR, CAN spam, ROSCA, etc., is $40,654. Again, per violation, not necessarily per call, large potential exposure. Again, think Dish Network. That case was brought, of course, based upon calls that occurred before this fine increase, but still, you had the FTC in that case asking the court for in the $1 billion, I'm trying to remember how much, 2.2 or 2.3 billion dollars, just absolutely ludicrous. Dish fought the good fight. Unfortunately, they were still hit with the fine. The judge used discretion to impose a smaller fine, wisely, I think, of $280 million. But still, even if you get a judge who's willing to do that, these fines stack up so quickly, especially for organizations that make a lot of calls. Okay, now this is really, really, really important, guys. The ACA, the American Collections Association International, sued, along with 8 other private brands and trade associations, all sued the FCC in federal circuit court right after their July 2015 rule change. Remember, think way back, October 2013, we had the new wireless rules, and then they clarified what an auto dialer is and some other things in July 2015.
Just said if we got 300.
The FTC gets sued. I'm getting just a little bit of background noise. Someone's not muted. So the FCC is now facing this big appeal. It was fully briefed in writing last year. There was an oral argument held in October of last year that went way longer than the normal oral argument on an appeal like this, and the court just grilled the FCC lawyer. What's at stake? Well, the definition of an auto dialer, for example. Will the court overturn the FCC's broad, overreaching definition of an auto dialer that tries to capture systems that have even just mere future or potential capacity? Will they overrule the FCC and say that's too far? Maybe. Will they overrule the FCC's determination that consumers get to revoke consent any way they want, really, at any time and in any quote-unquote reasonable manner? What a burden that is on an organization that has to train anyone who has contact with consumers to be able to recognize and record and honor an opt-out. We should be able to condition that. The FCC has made that really hard, and that's part of this challenge. Also, the called party issue. If I call with permission, I have permission from person A, and I call that number trying to reach person A, but I accidentally reach person B, who's the new owner of the line, is that a violation? Well, the FCC says, yes, that's a violation after the first call. You get one free pass. That's not great relief. We're still getting some background noise. Nina, I'm not sure who that is, but I'm wondering if we can mute the other lines. Appreciate it. So will the FCC be overruled on this called party issue? If I make 20 calls before person B picks up and says wrong number, that's 19 violations. That's ridiculous. There's no perfect reassigned number scrub. There are some great scrubs out there that you should be doing, especially on your old data, but they're not perfect, so you've got exposure. We'll see. That decision is overdue. We will have a decision on that case literally any day now. The DC Circuit normally doesn't take this long to rule, and hopefully they're ruling on that fax case. If that's any indicator, I'm hoping we win on at least some of these issues.
We kind of created a bipolar with Ron. It's like you're making money. But
guys, I'm still hearing a little background noise. Not sure if the
Eric, this is Nina. I'm trying to get it muted, so I'm working on it.
That's okay. I will charge ahead. I'm hoping everyone can hear.
Thank you.
Okay. So, like it or love it, we have a new presidential administration. If you haven't been watching the news, or if you're like me and you've stopped entirely and deleted your Facebook account because of all the debate, we have a new president, a new administration. We have a conservative Republican majority on the FCC. We have new Commissioner Pai was already a conservative FCC commissioner. He's the new chair. He's the boss. We also have both Commissioner Pai and Commissioner O'Reilly speaking out against prior TCPA interpretations. What a great opportunity there is for some TCPA and maybe TSR reform or better interpretations in the coming months and years. What about nonprofits? I get asked this all the time. There is a lot of confusion out there, and understandably, it's hard to get a straight answer. This is the truth. In fact, just close your eyes. Don't even read this slide. Let me tell you the truth. I suspect that those of you on this webinar who are doing nonprofit calls, that most of you are not the actual nonprofit entity. Some of you are, but probably most of you are private fundraisers. You are a vendor or a professional solicitor hired by a charity to raise money. And you are making calls, probably a lot of cold calls, to try and raise money for your charity client. Well, what applies to you and what doesn't? This is the real truth. The calls from the charity itself, if you're one of the few that's an actual bona fide nonprofit entity or charitable organization, you are exempt from the FTC's TSR. You're also exempt from most of the TCPA rules because calls by or on behalf of a nonprofit are exempt. You're not exempt, though, from the cell phone rule, at least the old express consent, that implied express consent rule for cell phones. So if you're making charitable calls, whether you're the charity or the for-profit telefunder, watch out for cell phones. You can't cold call cell phones from an auto dialer and ask for money if you're a nonprofit. Can't do that. You need at least that implied express consent, the type you might have from a member or prior donor. Okay, what else? What about robocalls? A lot of charities think, oh, I'm a charity or I'm a telefunder for a real genuine charity, so I can robocall all I want. Not true. Since the Patriot Act, they snuck this little thing in the Patriot Act that basically amended the TSR to bring private for-profit telefunders of charities back under the jurisdiction of the TSR. What does it mean? Well, it means that that for-profit fundraising vendor has to refrain from robocalls unless they have consent, and that's the same for cells and landline. That goes back to the old, traditional pre-recorded rule. You can't deliver pre-recorded messages without consent, and that applies to the for-profit vendors that work for a charity. Now, thankfully, political calls remain exempt from all FTC dialer rules unless they cross the line and do telemarketing. Like if it's really just a ruse and they're just selling something and donating 1% to a charity. If you're acting like a telemarketer, the FTC is not going to treat you like a nonprofit. There have been a number of cases like that in the last couple of years. Some other behavioral rules, common sense stuff, no misreps, no credit card laundering, again, no cold pre-recorded calls. Also watch out, some states have stricter laws. Like California, for example, has a couple of robocall provisions, one that has no nonprofit exemption. Let's talk about consent. Consent is an end run to virtually all these rules. You can do almost anything you want with the called party's permission if it's well documented. Written consent per the FCC, and this is the type of consent you need for an automated marketing message, but as a best practice, you want to try and get written consent to send your non-marketing messages as well, even if you don't always need it. Written consent per the FCC isn't always just ink on paper. One of the only nice things they did for us in years past was they said, and this is in the very 2012 report and order that first published the rules that took effect October 2013 and created these written consent requirements. They said written consent can be obtained through a bunch of mediums, by email, text, on a recorded telephone line. You can get written consent, online web forms, etc. How do you do it, though? You've got to remember these keys: proper disclosure, in a conspicuous place, and good record keeping. Some examples. And, I see a lot of stuff out there. I'm not going to say if this is good or bad. People make fun of me when I'm the guy at the mall that runs up and grabs the sweepstakes card from the timeshare company and scans it, or takes a screenshot of, the little consent things I see around. But it can be done through a number of different mediums. What about obtaining so-called written consent on the phone? The FCC said you can do it. I've had arguments even with other lawyers about this, but it's in black and white in their own report and order. They said you can get written consent on a recorded telephone call. Here's an example. Again, don't cut and paste this and just assume you're compliant. Every context is different. Depends how you're going to use the consent, etc. So get with your counsel, and at least this might be food for thought, a push in the right direction. This could be done on a recorded line. Like for this example, let's say you have an inbound call. You found a compliant way to generate an inbound call. They called you. Now you want consent to make future automated calls to them, or text, etc. Hey, Eric, there's never any you never have to consent to our marketing in order to buy from us, but would it be all right for us here at Allen Legal to call and text you with offers and other information, including using our automated technology at this number? Yeah? Okay, great. I just need you to read back your telephone number to me one more time on this recorded line so I can confirm you agree and to make sure I've got the right number. Thank you, and you can opt out anytime. I think if you do it right, their response is an electronic signature under the e-Sign Act, and if you recorded that, good as ink on paper. Online consent for multiple brands. Ever since October 2013, this generic so-called opt-in data doesn't really fly anymore. You have to have consent tied to your brand name, not just preference data. So how does a lead generator, who doesn't always know at the time they are collecting consent who they're going to sell that lead to, get compliant consent? Well, this is one way I think you might try it. Again, I'm not certifying this is 100% compliant under every state and federal rule, but I'm saying I think if you do something like this right, it will work in most or all jurisdictions. I think this can be written consent that a number of brands could rely upon. This could be on a web form, for example, of a lead generator. By entering your number above and clicking submit below, you agree that ABC Inc., along with up to 3 of our marketing partners listed here, and click to read who will call you, may call and text you with offers and other information, including through the possible use of an auto dialer and pre-recorded messages at the number you provide. And you're not required to consent in order to purchase. Enter the number, submit, boom. I think you're going to win your lawsuit with that documentation. Again, maybe not. And you may, people have been sued in frivolous cases with even less rigorous consent. But this is one way I think you might approach trying to obtain consent for multiple brands on the same web form. And I can tell you we have had cases dismissed, at least some cases where this was the approach used. What about obtaining consent via text? This could be placed on a placard. When I retire and open Allen Hamburger House here in a few years, this is how I'm going to get people to opt into my marketing, my text marketing. Sign up for great text offers today. Just text, I agree to, insert telephone number, to receive up to 2 text message offers per week until you opt out. And you agree that Hamburger House may text you using our automated technology with offers and other info at the number you text us from, which you certify is your own number. You're not required to consent to purchase, and you may opt out at any time by replying stop or opt out. Standard rates apply, and additional terms are available at www.blah, blah, blah. I think you could use something like this to obtain compliant consent. Think about that. Before we do the tips, record keeping. Having good language is only half the battle. If you can't prove it years later when you get served with your lawsuit, if you don't have something very user-friendly to hang in front of a judge or regulator or plaintiff's attorney, it doesn't matter if you were compliant. You can't prove it. It doesn't matter if you had consent. They're not going to take your word for it. They're going to believe their client who doesn't remember or is lying to them and is telling them that they never consented. You need proof. So, for example, on a web form, capture a screenshot anytime the form changes so you can show what the consumer saw. Capture a time and date stamp, URL where the consent was obtained. All that data. You need that, and you need it in a user-friendly form if you're going to win your case based on consent. Okay, my final tips for reducing risk in 2017 and beyond. Review your scrubbing habits. It's not enough to say, oh, we got with our counsel 5 years ago, we set up some scrubbing, and we haven't been shut down by a class action yet, so it must be working. Don't do that. Review it at least quarterly or annually or something that makes sense based on your campaign. If you're scrubbing DNC, make sure you're scrubbing all the right state lists too. If you're scrubbing wireless, look at maybe scrubbing for VoIP too. There have been at least 3-4 cases I'm aware of where a judge was convinced by a plaintiff's attorney to hold the wireless phone in the same regard as a cell phone when the plaintiff was able to prove he paid per minute or paid for per message or call on his VoIP plan. So consider VoIP scrubbing if you haven't done that. Litigator scrubbing, this is relatively new. A number of great vendors out there, contact center compliance, have this wonderful new litigator scrub. I'll let them tell you about that. Regardless who you use, you just can't get away with not doing a scrub like this. Even if you think you're compliant, even if you are compliant, you do not want to call someone who has sued a call center or telemarketer before. Roughly 1/3, or at least 1/3 rather, of all TCPA lawsuits, at least 1/3 of all TCPA lawsuits are filed by someone who filed one before. We've got their numbers, or at least most of them. Do not call people like that. Get them off your list. You're not going to lose a lot of data like you would to DNC. I think these lists are up to, Ryan will tell us in a minute, maybe 100,000, 130,000 or something. But even if just 20 of those professional plaintiffs are in your data, they are landmines. They are ticking time bombs. Get them out of your list. Reassign number scrubbing. Do your reassign number scrubbing, especially on old data. Remember, it's a violation to call person B when you're trying to reach person A after the first call, even if person A doesn't pick up and say wrong number, or B rather. Police your vendors. Willful ignorance no longer flies. It's just so sad. I feel for Dish Network. I disagree with the FTC's position in the case. I was rereading that 500-page order, the findings of fact and conclusions of law last night. I just really feel for them. I feel like they were trying to do it right. A lot of the violations, it looks like, were committed by outside third-party vendors who violated their contracts with Dish, did what they were not supposed to do, and got Dish sued. It just, you've got to be extra careful. You can't just trust in your contract and believe your vendors when they say they're scrubbing, etc. Do your due diligence. Audit them. Check. If they're telling you they're scrubbing, you might want to still do your own scrubbing, etc. Avoid manual platforms that still quack like a dialer. If you've got what you think is a manual dialer, but it still is dialing in a million lines at a time and a lot of call abandonment, and there's clicking noises and answering machine detect delays, etc., people are going to think it's a dialer and sue you. Be very, very careful if you're using a manual dialer. I think you can. I think there are a lot of great preview platforms out there that are not auto dialers, but get with your counsel, get with your tech guys, make sure it's safe to call cell phones without consent. Resolve complaints. A lot of this stuff starts with a single consumer complaint. If you make that person happy, then they don't go call the FTC, they don't go call a lawyer, etc. Finally, I have heard a rumor there's a few insurance carriers out there who will write a TCPA rider for your existing corporate insurance. Shop around, find that coverage if you can. It may be pricey, but get it. Finally, stay tuned, stay alert, attend events, sign up for, with law firm email alerts, dnc.com, the FTC and FCC, you can sign up for weekly alerts. Stay in tune. This is a quickly changing regulatory environment. And with that, I will hand it back over to Ryan and my other friends at dnc.com.
Thanks, Eric, for the great information and for kind of breaking things down for folks. We've got a lot of questions that have come in, so I don't want to cut that short. I just want to kind of give an idea of some of the things that we get kind of the most questions on, and people tend to be confused about what you need to do compliance-wise and what we can do to help out as a vendor. These days, trying to run your compliance internally and not have a vendor is a dangerous business. It's almost impossible, especially with reassigned phone number scrubbing. And so when clients come to us kind of trying to fit together the TCPA puzzle, kind of the first thing you really need to look at is how are you going to separate your calls between manual mode and dialer mode, which means that you're going to need a way to at least scrub for cell phones, landlines, pull apart VoIP numbers, which is surprisingly a larger percentage of people's data than they might think. I've seen rates of 5 to 10% VoIP numbers, and if you don't take those,
and even more for B2B.
Yeah, exactly.
Much bigger percentage for B2B. Yeah.
And if you don't take those numbers out of rotation on a dial, they end up showing up as landlines, and there's a lot of professional plaintiffs that have gone out of their way to get VoIP phone numbers that would qualify for TCPA, where they'll opt in and try to induce you to call them. It's a good idea to separate them out and at least manually call them until you know otherwise. Wireless scrubbing confuses folks because there's multiple databases involved and you get porting of cell phone numbers, meaning porting from landline to cell phone and actually back to landline as well. The scrub times on those, as far as when you actually need to process your data or how often you need to process for safe harbor, is very limited. It's only 15 days. And a lot of people have thought they've been exempt from this, the whole TCPA world. They only do surveys, you're only doing B2B, nonprofit work, which is not true, as we've seen by a lot of cases. And a lot of professional plaintiffs have latched on to some of these areas, like especially Eric mentioned, especially in the B2B world, which is really kind of how we got into the litigation scrubbing business. Is a lot of our clients were kind of just doing baseline compliance to follow the rules, but they're still being targeted by TCPA litigators, either through threats or class actions. And so we've got about 130,000 phone numbers, believe it or not, that are tied to TCPA litigation. You can scrub them out and identify them either with your existing wireless or your VoIP scrubbing, or you can do it standalone. We even are now doing inbound scrubbing for TCPA litigators through an API and through a lot of our partnerships out there, where we're looking as these folks are coming into lead streams and on inbound calls, because that's where a lot of this originates. They opt in, and then they, like Eric said, they'll give you ambiguous language when they go to opt out, and then they'll hit you for a lawsuit. And then a lot of times they're tacking on the reassigned scrubbing piece, which is real easy to form a class under. So reassigned cell phone scrubbing is not the same as regular cell phone scrubbing. The only way to do it accurately is to use a vendor to hit it at the time of the at the almost as close to the time of the call as you can to check for reassignment. So reassignment is where the number has changed ownership. So someone consented to receive your offers, you got the proper consent, but then that phone number now belongs to another individual. You call the other individual, and then now you're on the hook after the first call with the violations or potential class action. So we actually looked at it on the reassigned scrubbing we've been doing for our clients overall, and we're seeing about an average of about 7% of the data that is actually reassigned that actually is is a risk. So that adds up pretty quickly. You got 100,000 phone numbers. You can easily have 7,000 numbers in there that are potential violations. And these a lot of times are, again, kind of set up where people buy reassigned phone numbers and then they wait for you to call them. There's a couple of famous articles about folks like Melody Stoops and others who that's how they fund their vacations. So something we can help you out with. We can do a test for that. We can do a test for professional litigators. We can also help you with verifying who these folks are, so when they are opting in, you can determine that that they are truly who the person they say they are, so you can track that as well. So we can definitely follow up with you. And so if you wanted to test your data for litigators, reassign phone numbers to get an idea of risk, or even VoIP phone numbers, happy to do that for you. Also got a couple other quick announcements. We're also gearing up for the DC Circuit appeal decision, which could happen any day. We've also got another webinar teed up for kind of a rapid fire. As that's released, we're going to immediately be putting on a webinar and dissecting the information that's coming down. Hopefully some good news for change. So stay tuned for that. We'll also be at Call Center Week, end of June, booth 322. So look for us there. We'll have a wine drawing, and our winemaker/CEO will be there to answer all your wine and compliance questions. So I'm going to turn that back over to Eric, and we can get into some of these very interesting questions that are coming in.
Questions, and those that don't get their question answered now can submit those through contact center compliance, and we will get them answered quickly.
All right, Eric, it's Nina. We had a question earlier on if a caller opts to take advantage of our hold my place in queue and call me back when it's my turn technology. Does the DNC or TCPA apply?
Read the beginning of that again. I want to make sure I understand what they're doing.
So it's the taking advantage when the customer opts to take advantage of the hold my place in queue and call me back when it's my turn.
Okay, I understand.
Technology.
So if I understand the question right, they're asking if I'm using dialing software that, and what they didn't clarify is if it's inbound versus outbound. But in the outbound example, like if I'm using a predictive dialer and I call, predictive dialers always call more lines than you have agents available, of course. And if the recipient picks up and says hello, then the system tries to find an available agent and connect them. But if you don't have an agent available, and you want to keep them in queue and give them the option of pressing something to remain, that's actually illegal. You're required by the federal rules to play a call abandon message within 2 seconds of their completed greeting. It's considered an abandoned call by law within 2 seconds, and you have to play a short message with your name, your callback number, the marketing purpose of the call, and an automated opt-out mechanism. Now, different analysis for inbound. If they called you, if consumer picks up the phone and unilaterally calls you and hits your automated IVR queue or whatever, absolutely, you can have a phone tree that says, hey, press 1 to remain on the line, or press 2 if you want us to call you back. Again, if you're going to call them back in an automated way, you may need some special disclosures there, but that can be done. But on the outbound, you've got a problem.
All right, thank you. Another question that we had is what are the rules for implied consent?
Great question. So-called implied express consent, again, sounds like an oxymoron, but this is right out of the mouth of the FCC. Implied express consent for automated calls and texts exists in the following situation. You get this implied consent when the consumer voluntarily gave their telephone number to the company in the normal course of business without any conditions on its use, and they haven't opted out or had their number reassigned. You get to call them back on a dialer as long as that call is closely related to the original purpose that the number was provided. So one more time, you get implied consent to make automated calls and texts for non-marketing purposes. Another key point, non-marketing only, like a debt collection call. You get an implied consent to make those automated calls when the consumer provided their telephone number directly to the company in the normal course of business without any conditions and they haven't opted out. And so long as the nature of the future call is closely related to the original purpose. Don't screw this up. There's a big giant pharmacy chain a year or two ago that when you drop off your prescription, they would ask for your telephone number because they want to send it an automated alert that says, hey, your prescription's ready. Seems pretty benign and useful. Well, they had, at least some of the time, they had trained their folks to say something like, if they were asked, well, why do you need my cell phone number? They would say, oh, that's just how we keep track of you in our system is all. That's just how we identify you. Well, that, right there, they accidentally conditioned the use of that number. They said, all we do is use it to keep track of you. So they really screwed up on that implied consent, because if they wouldn't have said that, then they would have had this implied consent for the automated messages. So you have implied consent. It's a non-marketing automated messages like a prescription refill reminder when the consumer provided their number to the company in the normal course of business without conditions and haven't opted out, and as long as the message is related somehow to the reason it was collected in the first place. You get no implied consent from just one other caveat. You get no implied consent from just capturing their number on Annie or something on an inbound. If they just call you, that's not them reading their number to you or writing it on a form. So don't cross the line. They have to actually voluntarily give you their number orally or in writing or something. They can't. It's not just based on an inbound.
Next question is, are phone customers sometimes charged by wireless carriers for the receipt of a ringless voicemail?
My understanding is generally no, but what you might be charged for is having voicemail service in general, and you might be charged to call your voicemail number and listen to your voicemail, usually not, but on some plans. But in theory, if the technology is working right, you should never see a charge for a delivery of that specific message. It shouldn't show up. Again, I'm not familiar with every platform out there, but the ones that I am familiar with, no charge will show up for the delivery of the voicemail message. They should not be charged for the delivery, no.
All right, thank you. We have a question and ask for you to define a bona fide nonprofit entity.
Call your CPA or tax lawyer. I'll go ahead.
And then also on the for-profit side of things, can a for-profit call center use robocall on behalf of a nonprofit organization?
Sure. And I know this happens a lot. I mean, people who say, oh, we're nonprofit, you're probably a for-profit vendor raising money for a nonprofit. So this is a very important question, and you want to be able to reach people who haven't consented. You want to reach the fresh meat. You want new donors. I get it. There is a legal way to do it. This is the rule. First, you or your client better be a bona fide real charity. If it turns out that you're just kind of what's a good example? Last year, the FTC sued a handful of cancer charities. Or purported cancer charities. Their documents, their corporate documents, they were filed as charities, but they weren't acting like charities. The FTC was able to prove in the litigation that they were really being conducted day to day for the gross extreme profit of their owners and vendors and managers and their buddies. So you got to be acting like a nonprofit. And how to do that, that's not up to me. That's for your CPA or your tax lawyer. So once you meet step one, make sure your client that you're raising money for is a true charity and not a front. Then you go to step two. Well, what can I and can't I do? I think the question was, can I robocall, i.e. can I deliver a pre-recorded message soliciting donations? I suspect is what they want to do. The answer is this. Even if the charity, the bona fide charity is exempt from the TSR, you're not as the for-profit vendor. You're not. You're subject, since the Patriot Act, you're subject to the TSR and the robocall ban. Or not ban, but the rule. What does that mean? It means even when you're calling on behalf of a real charity, you don't get to deliver a pre-recorded solicitation without consent. Unless, and these are the exceptions, unless, again, consent is one, but the other two are if they are a prior donor or if they are a current member of your client's organization. So no, you cannot just cold robocall to raise money if you're a private for-profit telemarketer. There's some creative things I think you might be able to do if you're really, really careful. Like maybe you lease the technology and the agents and the infrastructure. Maybe you lease all of that tech and infrastructure to the charity, and then the charity is really making the call on its own, and the charity's exempt. So I think there are some end runs. Also for political, if you're raising money for a political organization, that is completely exempt from the TSR. Except if you start falling into their definition of telemarketing, if you start selling things, then you got to look at that again. Hope that answers that.
Thank you. I have a question on call recording. So can we hit on call recording and letting a potential customer know that this call will be recorded for quality purposes?
Yes, you can, if you tell them at either the beginning of the call or the very beginning of the recording. There are a handful of states, especially California, where it's illegal to record a call without the other party's consent, or at least knowledge. Courts have consistently held, though, that if you tell the call recipient that it's being recorded or monitored and they stay on the line without objection, they have impliedly consented to the recording or monitoring. So yes, you can turn on recording, or you can record the whole call. You just need to tell them at the beginning that it's being recorded or monitored. That's very easy to sneak in there. That doesn't offend people these days. Hey, this is Eric calling from Allen Legal on a recorded line, blah, blah, blah. I mean, it's just do it every time. Don't try and separate out the two-party or all-party consent states. Don't try and only give it when calling a California, because you never know for sure these days where someone is actually sitting when they pick up the phone. You may think they're in a one-party consent state and you're fine, but they may actually be in California that day and protected by California law. So yes, you can record as long as you always tell them at the beginning. There are a lot of call recording lawsuits out there, especially in California.
Perfect. What about in an outbound established business relationship calling campaign? If a dialer detects an answering machine, can you leave an automated recorded message?
Read it for me one time. Was it B2B?
Mm-hmm.
Read it.
EBR.
Read it for me one more time. Oh, EBR. Sorry. Just read it once more.
Yep.
My apologies.
In an outbound EBR calling campaign, if a dialer detects an answering machine, can you leave an automated recorded message?
Okay, so it's an outbound call, and I assume a marketing call. An outbound marketing call that detects, or to an EBR, meaning like an existing customer. EBR is defined as someone who, basically, it's a little more complicated, but basically who paid you within the last 18 months or who made a product inquiry within the last 3. So you're calling customers or recent inquiries on a dialer. If your system detects an answering machine, then this is tough, and this came up. Call abandonment came up in this really unfortunate Dish case recently. I'm trying to remember exactly what they said because I thought it was really insightful. You're on any abandoned call, meaning if the human picks up, then it's treated as an abandoned call within 2 seconds. But if an answering machine picks up, that's not an abandoned call, and you can leave a recording. But this is the rule. There are other rules about what that recording has to say. If the message can be received by an answering machine, the rules say it has to say certain things, like the name of the company on whose behalf the call was made, that the call was for marketing purposes. It has to verbally state the callback number. And why do you have to read out the callback number? So that they can call back later and make an opt-out. Your automated opt-out option won't work if they're listening to their voicemail. So that's the rule. The EBR analysis doesn't matter so much on that rule. It doesn't change the analysis, in my opinion, if I understood the question correctly. If not, email me.
Okay. And I know it's 2:59. We got 2 more questions. Did you want to go ahead and do those? Okay. What are the rules for agent-initiated SMS mass messaging?
So if an agent, let's say an agent's sitting there looking at their computer, they're logged into the CRM, and they upload a contact list and upload a template and press go, there is an extremely good chance that most courts and regulators and plaintiffs' attorneys would view that as an auto-dial text. Why? Because it was sent en masse from a system that clearly has the capacity to send en masse. In my opinion, the only way to safely send a text message, a marketing text message, is if you either have consent or if the agent manually sends them one at a time using a system that cannot send messages en masse. So short answer is no.
And then are auto dialers allowed to call cell phones without consent for credit card notifications? What are your thoughts on that?
If by credit card notification you mean it's a bank sending an automated alert that or I'm sorry, it could be a seller. Let's say you're a seller of a diet supplement or something, and you have a customer on a rebill continuity type plan, negative option as the FTC would call it. And let's say you want to send them an automated alert that their card declined or is about to expire. I don't think those types of credit card alerts are marketing. Now, you could easily cross the line if you accidentally sneak any marketing content into the call, or if there's some sort of underlying marketing purpose, like a renewal type purpose. But as long as you're very careful and don't cross the line and become marketing, then you only need express consent to make that predictive or auto-dialed call to the cell phone or text to the cell phone. Remember, you just need that implied consent for non-marketing. The written consent is for marketing. And guess what? Thankfully, smiley face, you get that implied consent if that credit card holder had given you their number, their telephone number, in the normal course of business without conditions, and they haven't opted out, etc. So you probably do have the right consent to send that. If they gave you their number, like when they bought the diet supplement, if they entered their number in online when they signed up for the rebill program, you have permission to call them at that number, including from an auto dialer, for non-marketing purposes until they opt out.
All right. One last came in, the violation when calling a number that is thought to be accurate. However, the person that is at the end of the line is someone else. Can you just explain that just a little bit more, and we'll finish up?
Okay, wonderful. What a great last question. And the law on this could change literally this afternoon. That we are way overdue a decision from the DC Circuit Court, who is going to rule any day now. I mean, it could be a few more months, but it'll be soon. The DC Circuit is going to rule on the FCC's interpretation of an auto dialer. They're going to rule on the FCC's consent revocation rule, and they're going to rule on the FCC's one free pass rule for wrong and reassigned numbers. This is, if you've got consent, you're trying to reach person A, like your example, but you call and you accidentally reach person B. Let's say they're the new owner of the line, for example. This happens a lot. As Ryan pointed out, there's a very good chance that 7% or more of your data is reassigned, is those subscribers, someone else for those lines. You get one free pass, meaning the first time you call that number, if it truly was innocent, no liability under the TCPA. But the next time, you're basically strictly liable, even if they haven't picked up and said wrong number. So let's say you call them 20 times, and on the 20th time, person B, who you don't know, picks up and says, wrong number, this is my new line, leave me alone. That's 19 violations. Isn't that a dumb law? But that's the law right now. Again, it's being challenged. I'm hoping the DC Circuit overrules it any day now, but you never know. And either way, do reassign number scrubbing and mitigate that risk.
Perfect, thank you. And then the DC court decisions will apply to the whole country, correct?
Yeah, that will be, I mean, in theory, it could be appealed to the U.S. Supreme Court, but it will be, when it comes out, a binding decision. It will affect the FTC or the FCC policy in general, and it will need to be followed around the nation.
Well, gosh, thank you once again, Eric Allen and Ryan Thurman. Definitely a lot of impactful and useful information. Remember, we will send out a link that will give you access to today's deck, recording, as well as Q&A. If you have any questions or would like to schedule your free test that Ryan was talking about, you can contact us. at the information support@dnc.com. We do thank you all again for joining, for staying with us a couple minutes after. As always, Eric, a ton of really great information. Thank you once again for joining our webinar, Advanced TCPA and DNC Compliance, Reducing Risk in 2017. Thank you so much. Take care.
Thank you, Nina. Always a pleasure.
Thank you.